subject now. If I may, if my colleagues have got nothing further that they want to raise on this point. This morning, I registered that we would want to deal with all the legal issues, as it were, in one chapter. I think that's easier. I hope it's easier for you. I think it's easier for us. And of course, in the course of this week alone, we've had some 10 hours of evidence on this from the Attorney General and from 3 senior civil service legal advisors who were involved in the question. For that reason, we don't propose to try to go through the issues point by point again, which will take probably another 10 hours. But we really would like now to focus on the questions that most directly concern you as Prime Minister. And the committee has suggested that the easiest way of tackling this extremely complex subject with all of this 10 hours of background behind us would be if I tried to summarise first what we as a committee have heard and read on this subject. And if you will forgive me, though it will allow you to rest your voice for a minute or two, this will take me a few minutes, though I think ultimately will also save us some time. So to your content, I will try to wrap up what we have absorbed on this subject in a number of points.
Before, just to interject, and then coming to specific questions based on that, is that satisfactory to you?
Yeah, and so I'll go through the summary. If you're not content with any points in it, please tell me. And then I've got 1 or 2 questions I'd like to ask arising from that. Firstly, there wasn't a legal basis, as Lord Goldsmith repeated to us the day before yesterday, for regime change as an objective in itself. Secondly, lawyers in the US administration favoured what was called the revival argument, and that meant that the authorization for the use of force during the first Gulf War, embodied in Resolution 687, was capable of being revived as it had been revived in 1993 and 1998. However, the UK's lawyers did not consider that this argument was applicable without a fresh
into the Iraq inquiry, Tony Blair giving evidence, but at the moment Sir Roderick Lyne is really trying to summarise what the committee has heard about the legality of the war, and when he's completed that summary, they will then return to the questioning of Mr. Blair. And that questioning will continue until best part of 5 o'clock, and 5 Live will continue to broadcast those words until their conclusion. Then Drive will resume as normal.
Formed the view that there had been a sufficiently serious violation of the ceasefire conditions, and also because the force that had been used then had been limited to ensuring Iraqi compliance with the ceasefire conditions. And even in 1998, the revival argument had been controversial and not very widely supported. So the British argument was that you needed a fresh determination of the Security Council. If we turn then to the precedent of Kosovo, over Kosovo, Russia had threatened to veto a proposed Security Council resolution, and our lawyers believed that this precedent did not apply to these circumstances in Iraq, because in Kosovo we had had an alternative legal base to rely on, which was intervention to avert an overwhelming humanitarian catastrophe. So what that led to was consistent and I think united advice by the FCO's legal advisors, and also insofar as it was at this stage sought or proffered by the Attorney General up to November 2002, that a fresh UN authorization under Chapter 7 would be required for the military action contemplated against Iraq, contemplated at that stage as a contingency, to be lawful. Such an authorization, in their view, would provide the only grounds on which, in these circumstances, force could be used. So the UK and the USA went to the United Nations and obtained Security Council Resolution 1441, passed unanimously. However, in the words of Lord Goldsmith, that resolution wasn't crystal clear, and I think you yourself this morning referred to the fact that there were arguments. It didn't resolve the argument, I think was the way you put it. And the ambiguous wording of that resolution immediately gave rise to different positions by different Security Council members on whether or not it of itself had provided authorization without a further determination by the Security Council for the use of force. So up until early February of 2003, the Attorney General, again as Lord Goldsmith told us in his evidence, was telling you that he remained of the view that Resolution 1441 did not authorize the use of force without a further determination by the Security Council, that it was his position that a council discussion, the word discussion was used in the resolution, would not be sufficient, and that a further decision by the council was required. And I think perhaps as I'm about halfway through the summary, I've just reached the point before Lord Goldsmith gives you his formal advice. It might be sensible if I pause at half-time just to ask if, up to now, you think I've got it right in your own understanding.
Yes, I think that's a fair summary.
Right, well, if you're content, then I'll continue, and I hope to do as well with the second half, but I'm not the lawyer, and you are. On the 2nd of March, by the 7th of March, Lord Goldsmith submitted his formal advice to you, a document which is now in the public domain. And in that, he continued to argue that, quote, the safest legal course, unquote, would be a further resolution. But in contrast to his previous position, and for reasons which he explained to us in his evidence, he now argued that, quote, a reasonable case, unquote, could be made, quote, that Resolution 1441 is capable in principle of reviving the authorization in 678 without a further resolution. But at the same time, he coupled this with a warning that, quote, a reasonable case does not mean that if the matter ever came before a court, I would be confident that the court would agree with this view. So at that point, Lord Goldsmith had, to a degree, parted company with the legal advisors in the Foreign and Commonwealth Office, who've also given evidence to us through Sir Michael Wood and Miss Elizabeth Wilmshurst. They were continuing to argue that the invasion could only be lawful if the Security Council determined that a further material breach had been committed by Iraq. I emphasize the word further, of course, because 1441 established that Iraq was already in breach, but then the argument was about the so-called fire break and whether you had to have a determination of a further material breach. Lord Goldsmith told us that when it became clear that we were not likely to get a second resolution, a further resolution, he was asked to give what he described as a yes or no decision, especially because clarity was required by the armed forces. The CDS had put this to him, and by other public servants. He had received also an intervention from a senior Treasury lawyer. So, having given you that advice on the 7th of March, by the 13th of March, he had crucially decided, and this is from a minute recording, a discussion between himself and his senior advisor, David Bromell, who has also given evidence to us, and which is also on the public record. He had decided that, quote, on balance, the better view was that the conditions for the operation of the revival argument were met in this case, i.e., that there was a lawful basis for the use of force without a further resolution going beyond Resolution 1441.